Okay, what I want to do over the next 15 minutes or so is take you on what's going to be a fairly quick tour of the recent changes that have happened in employment law and what's to come throughout 2013 and beyond. Now, we're just over halfway through this current coalition government, and that means we're about halfway through their employment law review. A couple of years ago, they said what we're going to do is for every new rule, new piece of legislation we bring in, we'll take one out, so we won't add to the statute book. They've now ramped that up a little bit and said their policy is now 1 in, 2 out. So they've also talked about a red tape challenge, which is all very well. I think it's something that can be welcomed by businesses, but it's also something that has to be looked at with a bit of caution. Those of us who have been practicing law long enough know that when the government changes something, that their intentions might be in the right place, but it can often lead to unintended consequences or extra litigation where they didn't mean it. So what we're going to do is start by looking back, first of all, about a year to when the qualifying period for unfair dismissal rights was increased from 1 year to 2 years. Now, this is nothing new. It's something fairly uncontroversial. We had a 2-year qualifying period for most of the 90s. And what it means in practice, for those of you that aren't familiar, is that for the first 2 years of the employment relationship, an employer, the business, is relatively free to dismiss an employee without first following a fair procedure or identifying a fair reason. So that development is fairly uncontroversial. What I would welcome at the end, maybe in questions or afterwards, is any anecdotes you've got or sort of reality tales of whether or not this is something that would help your business or whether it makes no difference at all. The other thing to note there is that there are the usual exceptions to the 2-year qualifying period for things like whistleblowing claims, and also remember there's no qualifying period for discrimination claims. Next up, again looking slightly back, only a couple of weeks, is the a new development is that the right to unpaid parental leave has increased from 13 weeks to 18 weeks. Again, this is nothing controversial really. It's just an extension of something that was already there. What is quite interesting though is if we look ahead as far as 2015, the government is looking to introduce a system whereby parents will be able to share out between them a mother's right to a year's maternity leave. So what we could see in the not too distant future is a system whereby a mother gives birth, she's off work for maybe 2 weeks, and then for the rest of the year that she'd normally be off work on maternity leave, it's the father that takes those responsibilities. And what's quite interesting is that they've had a system like that in Sweden since 1974, and there, as you can see on the slide, we have, well, over in Sweden they have something called latte papas. I think roughly translated it's cappuccino dads, and that's because apparently if you go to a new baby group, a new parent group, most of the parents in there will be men and not women. So something that's perhaps going to change society in the next couple of years. So looking ahead now to summer 2013, we're going to see some quite drastic changes to the Employment Tribunal, and that's going to come in the form of the introduction of fees. At the moment, if you want to start a claim, if you're a disgruntled employee, you go on the Employment Tribunal's website, fill in the form, click send, and off you go. As you can see on the screen, the fees are likely to be £250 to issue a claim of unfair dismissal, and then £950 to take that claim to a hearing. Now, the government say the intention behind this move is to try and take away the cost of the Employment Tribunal from the taxpayer and put it in the hands of the people who use the tribunal. Obviously, though, it's going to cut down on claims. I can think of so many situations where an employee would not have claimed or would definitely have thought twice about claiming because of the fees that are involved. Those on the lowest incomes typically, I guess, benefits won't have to pay the fee. I think the impact this will have is that it will be mainly when we come to negotiating settlements, because undoubtedly once the fee has been paid by the claimant, it'll be on the table in terms of settlement negotiations. As you can see on the slide, it says judges will have the discretion to order the unsuccessful party to pay the fees paid out by the winning party. How they'll use that discretion, we'll have to wait and see. But at the moment, it seems that a claimant will be left with the choice of paying £250 with no guarantee that he'll get that back. So I think that's going to lead to a cut in the amount of claims we see. Next up, also coming in summer 2013, a new development is going to be that certain pre-termination negotiations are to be inadmissible in unfair dismissal claims. What does that mean? Well, first of all, we have to look at a problem that exists now, and that's if an employer wants to approach an employee and say, look, it's not working out for whatever reason, how about we offer you a severance package and we agree to leave on agreed terms. There are a number of issues with an employer doing that. First of all, if the employee says no, he or she can take the very fact that the offer was made as an indication that the employer no longer intends to be bound by the employment contract, and the employee can resign and claim constructive unfair dismissal if he or she has the requisite service. Alternatively, if the employee stays with the company, she could potentially argue that any process which then follows, maybe a performance review, something like that, a redundancy program, is predetermined and therefore unfair. And at the moment, that approach by the employer would almost certainly be capable of being referred to in front of an employment judge. You can try and label the approach or the correspondence without prejudice, although that is typically reserved for when there is already a dispute and there's an attempt made to settle that dispute. So what the government's proposing is that very conversation, that difficult conversation where you go along and say, look, it's not working out, they're saying that won't be admissible in unfair dismissal claims. So it's a step in the right direction, I think, and David Cameron has said employers must be able to have this frank discussion if they want to have it. As you can see there, the extension won't apply, or the extension to the without prejudice rule won't apply where there is improper conduct. What does that mean? I think potentially we'll see litigation over that, and that's where the system might fall down. There has been suggestion that improper conduct might include repeatedly asking someone, repeatedly approaching someone and offering them a severance package. Apparently it doesn't extend to discrimination. So what if you approach a worker who's in their 60s and say, look, is it time to hang up your boots, potentially? There could be a claim of unfair dismissal there. There could be a claim of age discrimination. So that's one that we'll be watching, and hopefully it will mean greater flexibility for employers. So next up, also coming in summer 2013, a new cap on the unfair dismissal compensatory award. So this is how much a claimant who's claiming unfair dismissal can recover in terms of his ongoing loss of earnings. At the moment, the cap's £74,300, and from the summer, it's going to be the lower of the claimant's salary or the existing cap. So if you're in receipt of £20,000 per annum, you're dismissed. The claim you can make for unfair dismissal is limited to £20,000. My opinion is that this isn't going to make much difference in practice. A lot of unfair dismissal claims are well under £10,000 or worth well under £10,000. The government say, well, it will help manage expectations for employees, perhaps more certainty for employees. I think there's some merit in that. I've had clients where their former employees have come to them and said, well, look, if I go to the employment tribunal, I'm going to get £74,300 exactly. And that's not true for a number of reasons. That it's in theory possible, but it's very unlikely to happen. So at least people will get a better idea of what they can and can't claim. Then, coming up in autumn 2013, or at least it was coming up in autumn 2013 when I wrote this slide, was the introduction of employee shareholder status. Let's just look at what that is before I say why it's potentially not coming up. You might have seen it in the press. It's George Osborne's idea, and that is that employees will give up key employment rights like unfair dismissal, the right to a redundancy payment, in return for some shares in their company. The shares have to be worth at least £2,000. Now, the interesting thing about this is that the government consulted on these proposals for 3 weeks, which I think is terrible, because if you had a 2-week holiday booked, you'd miss it completely almost. And the response was 92% of respondents either had negative or mixed views about it. So can anyone guess what the government did in response? Anyway, so they brought it in, obviously, or they attempted to bring it in, until yesterday when it was defeated in the House of Lords. They voted against it. And I think one of the quotes actually mentioned slavery and said this is, potentially amounting to that, because you're buying people out and you take away their fundamental rights. It's not completely dead in the water, because it will go back to the House of Commons, and it may well be that it's resurrected with some changes. But it's got many holes in it. The tax considerations, legal, corporate considerations were all going to be a real headache. And then what I want to do is just finish on pensions auto-enrolment, mainly because I've had a few questions about it recently. And in your handouts that you've all got, there's a lot more on this, and indeed all the slides. But I just want to cover while I'm speaking here is when does it come in? How much is it going to cost you, and can you get out of it? I think are the questions I would get most. What it is, for those of you who don't know, is that the government are introducing legislation whereby all employers are going to have to automatically enrol all eligible job holders into a pension scheme, and they can opt out if they want. So when is it coming in? It depends how many employees you've got, and it very much, well, as you can see on the slide, if you've got fewer than 50 employees, you're okay until 2 years in June. But those are just rough guides, so you're advised to check properly. How much is it going to cost? There's a breakdown of what the employer contributions are expected to be, so 3% eventually. And can you avoid it? Well, it's going to be difficult. There will be anti-avoidance measures in place. For example, you won't be able to ask someone in a job interview, if you got the job, would you opt out of the pension? And things like that are mirrored throughout the legislation. Of course, the employees can opt out if they prefer, and you have to, every 3 years, enrol everyone back in and see if they opt out again. So that's pretty much my summary of what to expect in the coming months and years. There is a lot more in the handout. The handout is detailed, but obviously I couldn't speak to everything in the time allowed.